You come home to chaos. Your front door's been kicked in, couch cushions everywhere, drawers dumped on the ground. And sitting on your kitchen counter, a piece of paper that says, search warrant. Here's what they don't tell you. That search warrant may be completely illegal. Most people think a warrant means that police did everything right. But I've seen warrants based off lies, warrants to search the wrong places, and warrants used as retaliation. In Missouri law, gives you tools to challenge every single one of them. Let's get into it. The judge may only rely on the written application and any written affidavit. Oral testimony cannot be considered. If it's not written on the paper, it doesn't exist. Before we talk about bad warrants, you need to understand what a good warrant looks like, because that's usually where things fall apart. In Missouri, a search warrant needs 3 things. 1, probable cause, backed up by a sworn statement in writing. 2, specificity. The warrant has to say exactly what they're searching and what they're looking for. 3, judicial approval. And here's the key. The judge can only rely on what's written in the application and any attached affidavits. No hallway conversations, no winks, no nods. Missouri Revised Statute 542.276 is crystal clear. If it's not in the application and not in the affidavit, it doesn't exist. So when a judge signs that warrant, they're supposed to be reading actual facts that show a fair probability that there's evidence of a crime at that location. No hunches, no rumors, real, verifiable facts. And that's exactly where the first challenge comes in. Probable cause isn't I have a feeling. It's not somebody told me they heard something. It's supposed to be actual evidence pointing to a specific place. But here's what happens in the real world. Officers hear third-hand gossip. No follow-up, no witness interviews, no checking security camera footage. They write it down, a judge rubber stamps it, and boom, your door gets kicked in at 6 in the morning. I've seen it firsthand. An affidavit that says a reliable source told us with 0 follow-up. That's not probable cause, that's lazy police work. In Missouri, when that happens, you file a motion to suppress. You're asking the court to throw out everything the police found because the foundation was rotten from the start. And here's what matters. Missouri courts look at the totality of the circumstances. They ask, would a reasonable person looking at these facts believe that evidence was there? If the answer is no, everything that they seized is generally inadmissible at a trial. And that brings up something even more powerful. This is a tool that most people have never heard of, but it might be the most powerful weapon you have, the Franks hearing. Here's the deal. If a police officer knowingly or recklessly lies, exaggerates, or leaves out major facts in their warrant application, and those falsehoods are necessary to establish probable cause, the entire warrant collapses. Missouri generally follows the federal standard. You must establish 2 things. 1, the officer knowingly or recklessly made false statements or intentionally or recklessly omitted critical facts. 2, once you remove those false statements or correct the omissions, there is no probable cause left. Let me be clear, mistakes don't count, typos don't count, negligence doesn't count. You must show the officer either knew that the statement was false or acted with reckless disregard for the truth. But when you can prove it, game over. The warrant fails. The evidence is suppressed. All of it. And here's the key part. Missouri courts do not apply the good faith exception when officers lie to get a warrant. If you prove a Franks violation, the warrant is done. Think about it. The officer swears that the controlled buys happened at this address, but the body-worn camera footage definitively shows that the buys happened several blocks away. Or they claim that the informant is reliable when they know that that informant has failed several polygraph tests and has a past history of making false reports. That's when you demand a Franks hearing. It's not easy. It's not automatic. But when the facts are on your side, it's devastating. Okay, let's say the warrant itself is valid. The judge signs it, and the probable cause is solid. But police still have to follow the rules when they execute the search. Missouri law and the Fourth Amendment say the exact same thing. Officers must stay within the four corners of the warrant. They can't expand it. They can't improvise. They can't turn it into a fishing expedition. If the warrant says a specific address, the search has to happen at that address. If it lists certain items, they can only search places where those items could realistically be found. If the warrant is narrow, the search has to be narrow. Here's the general rule Missouri courts use. When police go beyond what the warrant actually authorizes, the search becomes unconstitutional, and the evidence seized can generally be suppressed. A Missouri Supreme Court case made this crystal clear. In that case, officers had a warrant tied to one location, but seized the item from a completely different location. The court didn't mince words. If the officers search in a place that the warrant doesn't cover, the warrant doesn't protect them. The principle is simple. The warrant controls the search, not the other way around. And when officers ignore those limits, what happens next is predictable. Evidence gets thrown out, the prosecution's case collapses, and if the violation was intentional or reckless, you might be able to pursue a civil rights claim. Scope violations aren't technicalities. They're guardrails. They're what keep a warrant from being an excuse to search anything and everything. This is a scenario that should scare everyone. The government using a search warrant not to solve a crime, but to punish someone. Journalists, whistleblowers, political critics, people that have sued the city. I've seen cases where warrants were obtained based on fabricated claims, or where police deliberately withheld exculpatory facts, not to find evidence, but to intimidate. Missouri courts take this seriously. If an officer bends the truth to get a warrant, judges aren't going to clean up their mess for them. A warrant built on lies doesn't survive. Simple as that. And in those cases, suppression of evidence is just the beginning. You can file a civil rights claim in federal court. You can sue for unlawful search and seizure, First Amendment retaliation, malicious prosecution, and damages for the harm caused. These cases are rare and they're hard fought, but they exist. And when the facts show deliberate abuse of power, Missouri courts don't look kindly on it. All right, let's bring this home with action steps. If your home was searched and you think there was something wrong with the warrant, here's what to do. 1, get a copy of the warrant and the affidavit. Every page, every attachment. You're entitled to see what the judge saw. 2, document everything immediately. Time, date, who entered, what rooms they went in, what they took, what they damaged, photos, videos, everything. 3, don't fight this yourself. This is not a DIY situation. 4, contact a criminal defense attorney who knows how to file a motion to suppress and knows how to request a Franks hearing. But here's the reality. Arguing with police at your door doesn't help. Posting rants on Facebook doesn't help. What helps is building a factual record that a judge can review and finding the legal defects that make the warrant fail. That's how you win. Look, most people think that when a judge signs a warrant, that's it, game over. But that's not true. You can challenge the probable cause, you can demand a Franks hearing, you can suppress illegally obtained evidence, and when your rights are violated, you can sue. I'm attorney Matt Wayman. Stay informed, stay calm, and remember, the system doesn't always tell you about your rights, but they exist, and you can use them. If this helped, check out my other video on what to do when police show up at your front door for a knock and talk. It's the conversation that police want to have with you before they apply for a warrant. See you next time.